Welcome, everybody. Good afternoon. My name is Michelle Nadeau. I am the Legal Education Director for the Labor and Employment section of the Florida Bar. We're happy you joined us today to learn about the Choice Act, which is new legislation regarding non-competes. Our speaker today is James Poindexter. He practices labor and employment law in Jacksonville, where he was born and raised. He's a partner at Delegal, Poindexter, and Underkoffler, and a past president of the Florida chapter of the National Employment Lawyers Association. He attended Rollins College, got his law degree from Florida Coastal School of Law, and he has a master's degree in business administration from Jacksonville University as well. He presented on this topic at Advanced Labor Topics, and we thought that it was a important enough issue that we should bring it to as many people as we could. So we're happy that we have so many joining us today to discuss this. And I'm going to actually, I'm going to give you the CLE number. I forgot that. The CLE number is 9199. It's 9199. I'll give it again at the end. But that is the CLE number. And I'm going to turn it over to James, who is going to tell us about the Choice Act.
Thanks so much, Michelle. Let me see if I can get the PowerPoint working here without incident. And it's going to do my presenter mode again. So let me try that one more time. Okay. And I'm going to be in front of it a little bit, it looks like, which is kind of neat. Well, good morning, everybody, or good afternoon. Technically, it's 12:03. There's a big change in store here for non-competes if this Choice Act is ultimately signed by the governor. My understanding is it has not been sent to his desk for signature yet, but it did pass both houses of the state legislature. So let's get started. I think it's important to always start with where we currently sit in Florida as far as the non-compete laws are concerned. Florida's statutory framework currently prohibits restraints on trade or commerce. In fact, 542.18 specifically renders such contracts unlawful. A lot of people misunderstand the 542 and think that it is the non-compete statute. It's actually the antitrust statute. Now, there is a narrow exception in 542.335, which provides for certain restrictions on competition to be enforceable if they are reasonable in time, area, and line of business. Obviously, for those practitioners who are here who regularly practice non-competes or draft non-competes or advise clients about non-competes, that's where a lot of the litigation exists, is in understanding whether or not it's going to be enforceable as with a legitimate business interest. And checking out the statute every time is always key. But examples of legitimate business interests that traditionally have been required to enforce a non-compete are confidential information, specialized training, trade secrets, special relationships with customers. Referral sources have been found to be a legitimate business interest. And so obviously that's where a lot of litigation has been. Under the new statute, which is the Choice Act, which is Florida's Contracts Honoring Opportunity, Investment, Confidentiality, and Economic Growth, which is a mouthful, but call it the Choice Act. It does not replace the existing framework that we were just talking about. The way that it's crafted is actually a supplementation to that framework. It really expands the statute in order to create what feel kind of like safe harbor agreements. They are agreements that are presumably enforceable and going to be enforceable if certain notice conditions are met and they fit within the definition of a covered agreement. That's a departure from the normal statute, which, whether or not the agreement is enforceable is always at issue. Whether or not it's drafted in a way that's enforceable, whether or not there exists a legitimate business interest. if the agreement fits within one of these safe harbors, either as a non-compete agreement or a garden leave agreement, then it's going to be enforced under this statute as it's written. So let's get into the statute itself. In the House bill, there are legislative findings, which basically, in a nutshell, say that the current framework is inadequate to protect the risks that businesses face in the state of Florida. Obviously, that rings true for a certain audience here. I think others would believe that our Florida statute, which has been termed obnoxious by courts in other states, is more than adequate to protect business interests. But the legislature clearly disagreed and came up with the Choice Act. So let's get into what the act says. In order to be subject to one of these safe harbors, you have to be a covered employee. And a covered employee is an employee or individual contractor who earns or is reasonably expected to earn a salary greater than twice the annual mean wage of the county and the state in which the covered employee has its principal place of business, employer has its principal place of business, or the county in the state in which the employee resides if the covered employer's principal place of business is not in the state. So really, to be a covered employee, we're looking at how much the employee makes. There's really not a consideration about whether they have access to confidential information, whether the employee was given trade secrets or specialized training, or they have specific relationships with customers or referral sources. The whole ball game is how much money do they make? And if they make enough money, then they can fit within the definition of a covered employee. Interestingly, healthcare providers are specifically exempted from fitting within the definition of a covered employee under the House bill that was passed. Why that's significant is because healthcare providers, especially doctors, are going to generally fit within that amount of income. But as we've seen, there have been some pushback on the enforceability of non-competes in the healthcare sector, specifically because there is an important need for healthcare providers, especially in underserved areas, and the notion, much like attorneys, that patients should be able to choose their doctor and get the health care that they need. So the legislature did provide a carve out there. Covered employer is pretty simple definition. It's an entity or individual that hires a covered employee. So again, it all comes back to the income that the employee makes as to whether or not they're going to fit within the definition under the Choice Act. Now, there's two specific types of agreements that can be entered into, and they're not mutually exclusive. And that's an important point we'll come back to later. But there are these garden leave agreements, which garden leave, I understand, is a term that sort of became popular back during one of the Great Wars, where soldiers would be injured and would be essentially sent home, but continue to receive their pay. But they were required to do nothing but tend to their garden. Basically, they could do whatever they wanted. They were not engaged in military service or active duty. And so that's sort of the same principle that's being applied here, although it doesn't apply to being injured in any way. The notion is that the employer is basically paying the employee to sit out for a specified amount of time. Now, again, it has to be a written agreement, just like under the current statute, but it would be enforceable for no more than 4 years. So an employer could essentially pay an employee to sit out for up to 4 years while the whatever concern they have about them being in the marketplace atrophies enough, I guess, after that amount of time, and then they can re-enter and not be a competitive threat. Now, there has to be express notice before terminating the employment or contract. And then the covered employee agrees not to resign before the end of the notice period. So essentially, they give notice and say, hey, we're going to be terminating your employment, let's say up to 4 years. The employee has to agree that they're not going to quit during that period of time. And then the covered employee agrees that they're going to employ or keep paying them during that period of time, during the garden leave period. Now, it's interesting what pay they have to pay here is sort of itemized out, and you can read this in more detail. I'd encourage everybody to go read House Bill 1219. You can Google search it and you'll come up with it. But essentially, it's the base pay. It's not going to be any incentive pay or bonuses or benefits or any other type of compensation. So for commissioned employees who have a very low base pay, that may be something to look out for if you're advising them on these types of agreements. Now, a covered garden leave agreement, it's basically saying this does not violate 542.18 to monopolize trade or commerce in the state, so long as they are advised in writing to seek counsel. So there's some of that kind of OWBPA requirements here, and that the employee acknowledges in writing that they are receiving confidential information or they're going to have customer relationships. So basically, the employee signing the agreement includes an admission by the employee, even if it's at the start of their employment and they have no idea or they haven't received anything yet, that they are going to get confidential information or they are going to have access to customer relationships. Again, this is going to be enforceable. And notice it doesn't say that they have to prove that they had confidential information, it just says that they acknowledge in writing that they did receive that. So again, it's sort of, again, a safe harbor. We're not having a lot of provability issues here other than enforcing the written agreement itself. Another requirement is that the garden leave agreement states that after the first 90 days, the employee does not have to provide services. So the employer, for instance, could say, look, it's going to be a 2-year garden leave period. You're going to work the first 90 days, up to the first 90 days as a transition period. But then after that, you're free to engage in whatever activities you want, non-work activities. So tend to your garden if you'd like. Now, if you want to go get another job during that period, C sub 3 requires the permission of the employer. It doesn't specify whether that has to be reasonably given or whether there's any requirements of that. It appears to be completely at the employer's discretion. And then the leave period can be reduced during the notice period if the employer provides 30 days notice. That part can be a little tricky because if an employee signs a contract with a garden leave agreement saying you're going to be employed for 3 years, and the employee says, great, that's wonderful. Well, the statute specifically gives the employer to say, hey, actually, it's only going to be 30 days after the fact. And that's enshrined in the statute there. So that's, again, something to be considered when advising clients on whether or not to sign these types of agreements. They now there has to be a notice given to the employee, so they have to be, again, this is sort of OWBPA stuff that we see in the Age Discrimination Act, but they have to be given 7 days notice of the provision before an offer of employment expires. So basically, they get a week to look at it and think about it. And then if they're currently an employee, they have to be given a week as well to consider the agreement before signing it. Um, and then again, they included a second time that an employer may shorten the term of the notice period at any time during the notice period by giving 30 days notice to the employee. So that's in there twice, just in case, just to be sure, I guess. I want to take a break now, and that's sort of the garden leave agreements, and see if we have any questions specific to garden leave agreements. And I will take a look at the chat here. Um, Yeah, so good question from Adam Kemper here. Where can we find the average salary per county uh, for purposes of determining eligibility and coverage of employees? Um, that's a great question. I know the Department of Labor has data on a nationalized level. They may have it on a state by state level. I am not aware of how you find out on a county by county level, whether the state provides that or not. Again, dive into the statute because there are specific definitions about what is the average and where to find that. Nathan Labar suggested that the DEO, that's the Department of Economic Opportunity, are the ones that handle reemployment assistance programs, or what everybody else calls it, unemployment benefits. They may have that data as well. Um, Annette Newman asked whether or not the prohibition on working for another employer during the garden leave period only applies to competitors or for anyone. And the way the statute's written, it appears it's for anyone. So if you want to go rewind videos at Blockbuster Video, you'd still have to get permission in order to basically draw two salaries. And I think that's probably the reason for that consideration. Um, uh, Carmen, great question. What factors would be present when a court invalidates garden leave agreements? It seems like, since it's sort of a safe harbor, as long as it meets the terms, so there's notice, it's in a written agreement, it's not going to exceed 4 years. Those are sort of the bullet point requirements. And it seems to me that, at least the way the statute's written, as long as it meets those requirements, the employee was given 7 days to sign it. Then it, as on its face, is going to be enforceable. And we'll get into the enforcement mechanism a little bit later, because it's identical for the non-compete and the garden leave agreements. Yes, I will share my slides. I will tell you my slides are a copy paste from the House bill, so I will certainly provide the House bill to everybody as well. Any provision that would happen in regard to enforceability if employer failed to give 7 days notice. I think that's really going to be one of the only arguments that an employee is going to have to try to invalidate one of these agreements, is either they weren't given notice, or they weren't advised to seek an attorney. Maybe it wasn't in writing, or didn't have those components in writing. They're going to be very technical on the face of the agreement issues, rather than a deep dive into whether or not the employee. Oh, that's the other one. They have to confirm in writing they receive confidential information or client relationships. Um, Oh, there are questions in the Q&A as well. My goodness. Bob, great question. If the employee declines to sign, can the employer end employment? If they're at will, I don't see any reason why not. Just like with non-competes, an employer can make it a condition of employment. There's certainly nothing in the statute that would prohibit that. Let me see if I can get to the Q&A. Oh, there is Q&A. Great. Um, Assuming the bill signed, you recommend tweaking existing template or non-competes a lawyer may be using as a template. Well, look, if you've got an employee that meets the safe harbor as far as being a covered employee, and then I don't see why an employer would hesitate to update the non-compete to make sure it complies with those provisions, because it's going to be much easier, as we'll see later, from an enforcement standpoint, for employers to get a temporary injunction if they meet the Choice Act's definition. Ian Fedderson, if salaried employees at a certain dollar amount are covered, does that include hourly employees or just FLSA type salaried employees? That's another great question. So there's a definition of salary in here, and it seems to be broadly defined. While the statute references salary, I don't have the page printed out in front of me. It seems to cover pretty much any form of remuneration that's paid to calculate towards that amount. Um, I assume if an employer provides notice that garden leave ends, the non-compete would be over. So if you have a garden leave agreement that also runs parallel with a non-compete period, I don't know that that's a safe assumption. Certainly, there's a provision, and we'll get into it under the non-compete section, that the garden leave agreement is reduced day for day or the non-compete agreement is reduced day for day that the employee participates in the garden leave. But I think the presumption on that would be potentially that if the employer says, okay, here's your 30 days notice, that the non-compete period could still run. But I expect that we'll see some litigation over that soon. Yes, this is the only legislation affecting garden leaves that I know of. If there's anything out there, though, that anybody else knows of, please throw it out in the chat or the Q&A. Is it retroactively applicable to existing agreements? Assume not. I think you're right, David Volk. I don't think it is going to be retroactively effective if it goes into effect July 1st. Okay. Robert Brock, how is this different than serfdom? I like that. I'm not sure, but great question. So I want to go ahead and move on now into the non-compete section because we're about 20 minutes in, and I want to save some room for questions after that. Um, Covered non, and I just went to the wrong, skip to ahead. Okay. Covered non-compete agreements. Again, it has to be a written agreement. And here's the kicker for a period not to exceed 4 years, right? So we get that same lengthy time period here that's with these agreements under the Choice Act that we don't see under the current statutory framework, which for employment, 2 years is sort of the rule of thumb, and under the statute is deemed reasonable. To go beyond 2 years, you would generally have to show some sort of exceptional circumstances. Here, 4 years is going to be enforceable. Um, and basically, the covered employee agrees in the document not to assume a role for any other business entity in which they would provide services that are competitive during the 3-year period preceding the non-compete period. So not just up at the time that they left, but for the 3 years before they left, that would be competitive with any of that. Um, and then or a position in which they are reasonably likely, it's reasonably likely that the covered employee would use confidential information or customer relationships. So again, this is something that's required to be within the agreement. But whether there is any analysis as to whether or not the employee would be likely to use or reasonably likely to use confidential information is not something that's really going to come into consideration, at least at the temporary injunction phase, which, as most practitioners in this area know, that's the ball game. If you win or lose the temporary injunction, that's going to determine whether or not the employee is out of the job pending the resolution of the case, or whether the judge has determined, no, you're not likely to succeed, employer, on the merits, and so I'm not going to enjoin the employee. Let's get on here. A covered non-compete agreement does not violate public policy, again, and is fully enforceable according to its terms. So we're removing the realities of the job. We're removing what the employee actually had access to. Any analysis about whether or not the employee actually had confidential information, or whether it's actually confidential, or whether the customer relationships are special, or whether they were the employee developed those types of relationships, or whether the training was on the job or was it specialized. All of that analysis goes out the window, and we're only focused on the terms of the agreement. And it provides that, again, they have to be advised that they have the right to seek counsel in writing. They acknowledge in writing that during the course of their employment that they will receive confidential information or customer relationships. Again, whether or not they know at the beginning of their employment or not that they are, and whether or not they actually receive it. As long as they say in writing that they are, then that's going to be enforceable. And then this is the part that I talked about. A covered non-compete agreement must provide that the non-compete period is reduced day for day by any non-working portion of the notice period pursuant to a covered garden leave agreement. So if you have a non-compete agreement and you have a garden leave agreement that's running parallel to it, while technically the notice of termination is that I'm going to be terminating my employment at the end of the garden leave period, the non-compete runs at the same time that the employee is participating in that notice period and not working day for day. So 4-year non-compete, 4-year garden leave agreement. At the end of the 4-year garden leave agreement, the non-compete period's up. It doesn't then run consecutively. So at least we get that. A covered employer must provide, again, 7 days notice from the offer of employment expires. So they've got 7 days at that point. And then if they're a current employee, again, 7 days from the date that an offer to enter into the non-compete agreement expires. So current employers, with employees who have non-competes, can offer them a new one under this one. If they're at will, I don't see any prohibition on saying, and if you want to keep working here, you have to sign it. And if they do sign it, then there's going to be the enforcement mechanism. So let's talk about remedies. They're essentially the same. And this again goes beyond what the current statute provides. Under the garden leave agreements, a court must, not may, not can, not after a hearing and notice and opportunity to argue it, must preliminary enjoin a covered employee from providing services to any business entity or individual other than the covered employer during the notice period. So again, it's not, okay, just competitors, right? It's any employer during the notice period. Now, once you're enjoined, then you as the employee can come in and ask the court to modify or dissolve the injunction, but only if the covered employee establishes by clear and convincing evidence, right? So we're beyond preponderance of an evidence, and we're not at beyond a reasonable doubt, but we're at that clear and convincing level that based on public or non-confidential information. So the employee can't use confidential information when trying to prove by clear and convincing evidence. They can only use public or non-confidential information. That the covered employee will not be performing during the notice period work similar to the services provided by the cover. So there's going to be, okay, so I'm not going to be competing, and the covered employer has failed to pay, or the covered employer has failed to pay or provide the salary benefits provided in the garden leave. So if the employer, you have a prior breach defense there that they breached it, or the business or individual seeking to employ or engage the covered employee is not engaged or is not planning to engage during the non-compete period, business activity similar to that engaged by the covered employer and in the geographical area specified by the non-compete agreement. This is confusing to me because we have references to a non-compete during a garden leave agreement, and they're actually two separate agreements. I don't see anything in the statute that requires you to enter into a garden leave agreement if you're entering into a non-compete or vice versa. So how this is going to get enforced and how this is going to get interpreted, I think is going to be the subject of a considerable amount of litigation right out of the gate. I would suspect that the plaintiff's bar is going to argue, well, if I've got a garden leave agreement with a running parallel non-compete agreement, then yes, I'm going to be prohibited from working for another employer unless I meet one of these three subparts. The corollary to that is, well, what if I just have a garden leave agreement and I don't have a corresponding non-compete agreement? Am I prevented from working for a non-competitive employer, or can I seek to dissolve the injunction because I'm not working for a competitor? And I don't know that this section was necessarily tailored to address that. So I pitched that to everyone here because I don't have the answers, obviously. But I would expect that people in this room are going to be litigating over that point when it comes to enforcing those. Now, the remedies for the non-compete agreement is very similar. Again, a court must enjoin, and it's a business, an entity, or an individual from engaging a covered employee. So here we see the injunction is against the employer rather than the employee. And I want to check something real quick because let me stop sharing my screen, because there was a difference between the Senate bill and the House bill. And I just want to make sure that we're looking at the House bill on that section before I go forward. So yes, so they actually changed this. The House bill is different, and I'm going to share here because the PowerPoint I did originally was based on the Senate bill, but it was the House bill that was ultimately passed. And if you look at this, upon application by a covered employer seeking to enforce a covered non-compete agreement, a court must enjoin a covered employee from providing services. So that's a distinction rather than trying to enjoin the company that the employee went to go work for. It's actually an injunction against the employee, which I think makes a lot more sense from an enforceability standpoint of the statute. But it basically says that during the court may modify or dissolve the injunction if they can establish by clear and convincing evidence based on non-confidential information that the covered employee will not be performing competing services during the period. That the covered employer has failed to pay or provide the consideration provided for in the covered non-compete agreement, and has had a reasonable opportunity to cure the failure. So if, for instance, the non-compete agreement is part of an employment agreement and the employer has failed to pay some type of compensation to the employee, that still would be a defense. However, the employer must have an opportunity to cure it. So the employee can't just pull that out in the injunction hearing and say, well, they failed to pay me money, because then the court has to turn around and say, well, we have to give them an opportunity to pay you that money in order to make this enforceable if it's truly at issue. And then again, that the new employer is not actually engaged in or planning to engage in competitive activity. So again, we got to change there, and I will update my PowerPoint before we send it out. But it's only really to that one point, which is obviously an important point. But I wanted to make sure that was clear. Let me share. Go back to the PowerPoint. Okay. Other provisions. So there is a provision in the Choice Act which requires that any information the employer deems to be confidential must be filed under seal. Now, anybody that's dealt with Florida's rules of practice and procedure regarding filing or sealing documents knows how much of a headache it is. You have to file a notice of designation of documents, confidential documents in the record. There has to be notice and a hearing on it. This appears to sort of modify that a little bit, because it basically just says the court has to presume that anything that the employer deems as confidential is confidential and filed under seal. So how the mechanics of that work will be interesting. But again, remember, the employee can't rely on confidential information at a hearing to try to dissolve the preliminary injunction. And so it would really be I'm not really sure what context the confidential records would then need to be filed, unless there was a dispute over what was confidential. Now, the second other provision here is something that's found in most non-compete agreements anyways, basically saying that the injunction is not the only remedy, so the employer can sue and seek damages. That's not really a big change, but it is enshrined in the statute. Same with the third part here, prevailing party attorney's fees. We already have that in the restrictive covenant statute that is on the books. This one's interesting. And again, I'm not really sure why the drafters did this, but they said, and this is in both the non-compete and the garden leave provision. It says that if the employee engages in gross misconduct against the covered employer, the employer may reduce the salary or benefits of the employee or take other appropriate action. So I understand that in the garden leave agreement. So if I go out on garden leave and it's a 2-year period, and during that 2-year period I engage in some form of gross misconduct, that maybe they can reduce the benefits that are payable to me under the garden leave agreement. But if I sign a non-compete agreement that's part of an employment agreement and I allegedly engage in gross misconduct, is this basically adding a provision of the agreement that says that my employer can reduce my pay, and that would not be a prior breach of the non-compete agreement? Is that how that provision is intended to work? Is that how it's going to be enforced? Again, I'd say the jury's out, but I don't even think the jury's been impaneled on this yet. We're going to have a lot of litigation going forward. And the last part is, to me, one of the more interesting provisions. At the very end of the Choice Act, it says any action regarding a restrictive covenant. Notice it doesn't say a non-compete. It says a restrictive covenant that does not meet the definitions of covered garden leave agreement or covered non-compete agreement as provided in this part is governed by 542.335. I think, and I'm saying I think because, again, all of this isn't even law yet, but perhaps what the drafters intended to mean there was, if you have a non-compete that doesn't fit within the definition of a covered non-compete, then we default to the statutory framework and the case law regarding that statute for enforcement of that non-compete. So in other words, if you don't make the threshold amount, you can still have a non-compete. It's just going to be enforced under the old method of determining what the legitimate business interest is. I think there's a second way to read this. Um, and I think that there is, in my mind, a question of statutory interpretation here. There's a principle of statutory interpretation that means the specific is going to govern over the general. And here we have a very specific statute that's been passed regarding non-compete agreements. 542.335 is a very general statute regarding all restraints on trade. It's not specific to non-compete agreements. It's any restraint on competition or trade. And so to the extent that there are other types of restrictive covenants, any action regarding a restrictive covenant. So we could be talking about a non-solicitation or a confidentiality provision, something of that nature. A non-disparagement clause can certainly be a restraint on trade or competition. That those provisions that don't meet the definitions of garden leave or a covered non-compete agreement, that those are going to still be enforced under 542.335. And how that ultimately gets resolved is going to determine whether or not covered garden leave and covered non-compete agreements are the only vehicle for non-competes in Florida, or are they just one safe harbor provision that allows for certain agreements against certain employees to be enforceable, and everybody else still has to contend with 542.335. So again, we're all speculating. I'm happy to go back down now into the Q&A and try to give you the answers I can. We've got plenty of time, so I'm going to shut down the PowerPoint here and focus more on the questions. Let's see here. Bob Regal asked, did the governor sign? No, it has not been sent to his desk yet for signature as of today, at least. So we'll have to wait and see whether or not it is ultimately signed. Michael Cantor asked, is a separate notice acknowledgement document necessary to satisfy the requirement that the employee acknowledge receipt of confidential information and that they have been given 7 days to review with counsel? Or can this language be in the non-compete agreement itself? I think it has to be in the non-compete itself. I think if you wanted to do it as a separate document, perhaps you could, as long as you've referenced the non-compete. But you want to make sure that those elements are at least documented one way or the other, because otherwise there's going to be a question about enforceability. Rosavilla, does a shortened garden leave period affect the enforceability or duration of the 4-year non-compete period? So if you've got a non-compete and a garden leave provision, and I think this is how it's going to work. Again, I think if the employer says 4-year non-compete, 4-year garden leave, but then 60 days into the garden leave says, hey, here's your 30 days notice. I think the employee is going to get credit for the 90 days on the non-compete, but the rest of the non-compete period, because it's going to be a separate provision, is going to still be enforceable. Because there's, mind you, in the covered non-compete definition, there's no requirement that you enter into a corresponding garden leave agreement, and vice versa. In the garden leave agreement, there's no requirement that you enter into a corresponding non-compete period. I think the hope here is that employers who are trying to engage with this statute are going to do both, but I don't see any requirement in there that you do both. And so if an employer does have both and cuts the garden leave short, I think the non-compete is still going to be enforceable so long as it met the other requirements. Ruth had a question here. I'm not sure either the DOL, Bureau of Labor Statistics data the drafters intended to be used for the annual mean wage of the county in Florida. Here's the link to BLS. Okay, great. So here's some BLS information. There's a link here in the comments in the chat if anybody needs that for census data for Florida. Jarrett Davis, for the 7-day review and consideration period, it sounds like an employee can waive the period by signing prior to 7 days. Thoughts? Yeah, I mean, there's certainly, and I think practitioners take different. I've seen employers take different perspectives on, like, for instance, the 21 day period in an OWBPA waiver. Can the employee sign it early, or do they have to take the full 21 days? Where I've seen, I think what makes the most sense is if the employee is going to waive it early, they have to kind of initial something that says, I understand I've got the 21 days and I'm waiving it and I'm, signing it early or whatever. But I think again, there's if the employee if it's enforced the way it's written, the employee has to be notified in writing that they have 7 days. So just strictly looking at that language, if I notify the employee that they have 7 days and they sign on day two, well, they knew they had the 7 days, so that's sort of on them. I would think most likely. Um, Oh, okay. No one can see the chat. So I am not going to read out this link because it's about 10 miles long.
James,
Uh,
I answered Ruth in the Q&A, so
oh,
people,
great.
I think people can see that.
Okay. Great. Yeah, it looks like we've got a lot in the Q&A, so I'll bump over there um, and see what what we've got um, in question and answer. Retroactivity, we did that. Did that one. Why do you think the employer would choose to use a garden leave agreement as opposed to a covered non-compete agreement? Great question. The only thing I can think of is we're talking about high earners here. And so I have often seen, where some companies will offer executives, sort of a golden parachute severance if they're terminated that is equal to the non-compete period. So for instance, they might have a 12-month non-compete. But because they're being terminated without cause, they get a 12-month severance or something like that, or a 6 month and a 6 month, or a 9 month and a 9 month. So this may be, like I said, sort of a slight encouragement to employers to do it. Maybe there's something in the market that high earners require or bargain for that during their negotiations and say, well, if you're going to put me under the non-compete statute for a covered non-compete, I also want an equivalent period of garden leave. Maybe that causes the employer to bring down the non-compete. Those folks who are in those positions can sometimes have more bargaining power than some lower income or lower earning employees who don't have that same ability to negotiate. So that's the only thing I can think of for that. Uh, why do you think an existing covered non-compete could not be enforced under the statute? So I think it could be if it meets the requirements, but I think there's very few of them that specifically state in the agreement that they were advised to consult an attorney and had 7 days to consider it before signing. I think there's some technical requirements that an employer may need to go clean up in order to make sure that a non-compete agreement meets the standards to be a covered non-compete. If all the elements are there, then I don't see why it couldn't be enforced. But at least in my experience, I don't normally see a notice and consideration period and that kind of thing, all the notice requirements met. Um, does the act require additional consideration for entering into the non-compete? No, it does not. As anybody who practices in this area who's litigated that issue knows that employment, or even just, hey, you got a job tomorrow, continued employment has been found to be adequate consideration for the enforcement of non-compete. So I would expect that same analysis, if someone tried to attack these agreements for a lack of consideration, would probably apply. Here's a question. So it is possible to hire an employee, have them sign a garden leave agreement, have them stop working after a week and keep paying them 130K a year for 4 years and basically take them completely off the market. Yeah, that's the intent. If the employer is willing to pay that premium to an employee who's not working, the notion is they're sitting out. I think from the employee's perspective, that's certainly more advantageous than sitting out for 4 years with no income in their market or in their area of expertise. But again, I think it's buyers beware on those because again, 30 days notice is all they need to terminate that. Um, so if I were unable to get this ridiculous law shot down on anti-slavery grounds, do we think the litigation will primarily be in the damages stage post-breach? I got to be honest with you. I've litigated these. I don't pretend to be, the pro from, on all non-compete issues. But when an employee loses the temporary injunction hearing, they lose their job. They generally lose the ability to continue to fight the litigation because, attorneys don't do these things on contingencies just in hopes of getting their attorney's fees back at the end of a 4-year non-compete fight. And so hypothetically, yes, if the law is not shot down and it continues to be effective, the question is going to come, okay, can we dissolve the injunction to let the employee get back to work if their employer will take them back at that point? And if they can prove by clear and convincing evidence that they're not engaging in competition, then I think there's a pretty good chance that employee may win that case ultimately. But then the question is going to become if they lose it, are there other damages that the employer tries to seek other than just preventing them from continuing to work? And I would rely on management side attorneys to advise on that. But going after an employee for a breach of contract and a large damages analysis in hopes that your client's going to recover some of their loss may just be throwing good money after bad, especially if they're enjoined from doing it. Richard asked if there's a bond required for an injunction. Not under this statute. Uh, Now, I'm not sure, but the general statutes on injunctions may require a bond, but at least the Choice Act does not specify how much the bond is or whether one is required. But I'd have to go back and revisit that. Phyllis asked, does providing services during garden leave also apply to volunteer services if, for example, the employer is in the nonprofit sector? This is an interesting question, and it actually comes up currently under the non-compete statute. For instance, if a doctor or any professional leaves their position and they're subject to a non-compete, the question of whether or not they can go engage in volunteer work that, if they were paid for it, would be deemed competitive, is, I think, a question up for litigation. And I believe there is some case law. I think there was something about I'm trying to remember the case, but it was like a doctor who was volunteering as like a sports um, uh, assistant, to like a high school football team or something like that. And the notion, or at least the argument, I think, was, well, would the high school have to pay someone to do that? And would that potentially be removing competitive work for which the former employer could be competing for? So are there arguments that volunteer services are competitive? There are, and they probably would apply in this case when trying to dissolve the injunction. What is the language regarding salary requirements for the garden leave and non-compete? We can take a look at that. I've got the statute pulled up here. We can go to definitions, and since we've got a couple of minutes here, I'll try to get to a few more questions. Let's see here. Salary means the base compensation calculated on an annualized basis, which a covered employer pays a covered employee, including base wage, a salary, a professional fee, or other compensation for personal services. So, and the fair market value of any benefit other than cash. So it starts out great by talking about base pay, but then ends extremely broad, which means, the value of any benefit and any compensation for personal services. Salary does not include healthcare benefits, severance pay, retirement benefits, expense reimbursement, distribution of earnings and profits, not included as compensation for personal service, discretionary incentives or awards, or anticipated but indeterminable compensation, including tips, bonuses, or commissions. So we start narrow, we get very broad, and then we get narrow again. Again, I think there's a lot to try to figure out and how we calculate the salary. Are the requirements for garden leave and non-compete substantially similar? Yes, they are substantially similar. So again, we've got it has to be in writing. There has to be the notice. The non-compete provision has additional language regarding, the employee stating, I think actually both of them require the employee to state that they're going to be receiving or have received confidential information. So again, I think the theory here is that these may run concurrently and that employees will get a benefit for it, but I don't know that that necessarily has to be the case. Are the new covered non-compete garden leave subject to equitable extensions? For example, an employer finds out around year 4 that an employee has been working without permission the entire time. It's not in the statute. Will that be a consideration that will be enforced? Perhaps if I'm an employer, I'm drafting the agreement to say that, just like I do with non-compete agreements under the current statute. There's always or oftentimes that provision that says if the employee violates this, then the restricted period tolls for the period of breach. Similar there, maybe there could, an employer might try to do a payback provision or something like that. Again, I don't want to put ideas in folks' heads, but there's probably ways to write that into the contract that may or may not be enforceable at the end of the day. Again, I expect if this is signed that there's going to be a good number of years where we're all trying to figure out sort of the boundaries of what is and is not going to be enforceable. Tyler asked, do you think we should include other restrictive covenants in a covered garden leave or non-compete agreement, or have those in a separate agreement? I do not see non-solicitation on disclosure provisions addressed in the Choice Act. They're not addressed, other than that very final provision that says any other restrictive covenants are going to be under the normal statute. So I think you can include them all in the same agreement, just like we do, or I often see now where it's all included within the employment agreement. Not necessarily separate restrictive covenant agreements or anything like that. And it's just going to be, okay, what's the enforcement mechanism for these various provisions? The non-compete, if there's garden leave, are going to be under the Choice Act, whereas the rest of it's going to fall under the normal statutory framework that we all know well. I've got about 7 minutes here. I'm going to make it through as many of these as I can. If I don't get to them, though, I'll try to reply in writing. Are prevailing party fees only applicable as against the employee party to the agreement, or also against the employer aiding a violation? So currently under the Choice Act, again, the Senate bill was a little different. And I thought the Senate bill had a lot of problems because the injunction that an employer could get was not against the violating employee, it was against their new employer. And then under that bill, they would have been able to get fees. Now, whether or not that would have ultimately withstood scrutiny, I think is a legitimate question. Under the House bill, that would be the one that becomes law. It's the employee that would be enjoined. Can the employer sue the employee's new employer under the Choice Act? I don't see that in the statute, but what I do see is like we would see under the normal framework is perhaps a claim against the new employer for tortious interference with the employment agreement. And whether or not an employer can get fees for a tortious interference claim, I believe the answer to that is no. But again, I think you'd have to sort of look at how that's normally done now. There's nothing in the Choice Act that would specifically address that. How would the injunction be entered? Just submit the motion for the filing of the complaint and request the court enter the injunction that must be entered, as opposed to an ex parte motion, enter notice of the hearing for it to be granted. Seems that it should be entered immediately, and upon a motion to dissolve is when the arguments are heard by the court. why the injunctive relief should be modified or dissolved. I think that's right. I think basically it would be an emergency petition for injunctive relief, temporary injunctive relief. And at least the first few times you do it, you're gonna have to spell out in there that the court must do this upon application. That's the language from the statute. Upon application, the court must enter a temporary injunction. It doesn't say upon notice in a hearing. It says upon application. Once the employee gets the order enjoining them from working, that's when the employee has the opportunity, now that they're out of the job, to file a motion to either dissolve or amend that injunction, modify the injunction. And that's where they would have to prove, using public or non-confidential information, that they are not working for a competitor by clear and convincing evidence. To confirm, it is 7 business, not calendar days. That's a good question. Let's take a look at the statute. Well, I thought I would get there by 7. Let's see here. At least 7 days. I think it's calendar. I think that would be calendar days in my book, rather than working days. So 1 week from when before the offer expires is how that would work. Did you ever answer whether the income determination is to be at the time of the agreement is waived? So if it's 4 years, by the 4th year, the amount could be different. Thoughts? I don't know. I don't know. There's not a very clear answer. We read the definition there, and I think, again, how we calculate it and what's the average for the county. Is it at the time it's signed, or is it at the time of enforcement? Is it at the time of the breach? Those are all very legitimate questions. And unfortunately, I think we're just going to have to practice with it a little bit before we find out the answers to those questions. Does the garden leave agreement have more leniency for geographical scope, so that more likely to be enforceable to restrict throughout the U.S. for the 4-year duration instead of reasonableness? I don't believe that the statute actually touches that. The way it's written, as you can see, is in the geographical area specified in the agreement. So again, there's not really an analysis of whether or not the chosen geographical scope is reasonable. It's you signed it, you agreed to it, and now it's enforceable. I think that's really, if I had to sort of put this in a sentence, that's what this statute is trying to do, is remove the discretion, remove the arguments of whether or not what I signed is legal or enforceable or factually correct, and just say, you signed a document that said you wouldn't compete. It's going to be enforced so that you do not compete, period, the end. No questions about it. You don't even get a hearing. You're going to be enjoined. And then if you want to try to make that argument that you're not actually competing, we're going to give you a high bar that you have to clear using non-confidential information. And that's where I think, as employee representatives, need to really advise their clients before they sign these things, that I often have people come into my office and they just go, yeah, I signed a non-compete, but it's not enforceable. And you just have to really rein people in and explain to them, even under the current statute, why it very well could be enforceable and why they need to reconsider that sort of flippant response. Even more so under this, there's just even fewer defenses. Would an agreement by the employer that it will not reduce the time period of the garden leave be enforceable? It seems like highly paid executives would negotiate that. So it's interesting. In order to be able to reduce it, I think the requirement under the statute is that the agreement includes a provision that says the employer can reduce it for 30 days. So if it doesn't have that provision in there, then I'm not sure that the employer would be permitted to do that. Again, that might be a point of negotiation where we say, okay, I'll agree to the garden leave, but we're going to remove this provision that says you can remove it. You just, can cancel it with 30 days notice. I'm going to do 1 or 2 more. I know we're going into overtime here, and I tried to speed through it because I anticipated a lot of questions. I may have missed it, but the employees subject to this act need to be physically located in Florida, right? Wrong. Uh, let's pull up that provision. Let's see here. I think it was place of business. Uh, let's see here. Primary place of work means the location where the covered employee spends more work time than any other single workplace. Um, so a covered garden leave agreement with a covered employee who maintains a primary place of work in the state, regardless of any applicable choice of law provisions. Um, It applies to a covered garden leave agreement with a covered employer whose principal place of business is in the state. So the employee has to have a primary place of work here in the state of Florida. But for instance, if they have a location that's outside the state and they commute into the state or something like that, there could be enforcement. I'm not sure how that works for people who telecommute. There may be some analysis similar to like what we see for counting employees under the FMLA and several other laws. Again, a great question, but not fully spelled out in the statute, where we can completely know the meaning of that. Um, we touched on that one about the how we calculate the pay. Uh, let's see here. Um, Is there a salary set off for secondary employment under garden leave provision? Nothing in the statute to that effect. Could you write that into the agreement and say, we'll give you permission to work for another employer, but it's going to dollar for dollar set off? Maybe. Maybe that would be enforceable. I'm not sure if that would violate the statute, which requires you to pay. But there doesn't seem to be a lot of guidance on that in the statute. Um, Oh, 14 of 26 of the bill, yes to enjoining subsequent employers. Let's see that because you may have spotted something I didn't see. Um, the business entity or individual seeking to employ or engage the covered employee is not engaged, is not planning. Um, Oh, here we go. Upon application by a covered employer seeking enforcement of a covered non-compete agreement, a court must preliminarily enjoin a business, an entity, or an individual from engaging a covered employee during the covered employee's non-compete period. So that language actually did make it into the House bill. I was wrong about that. Thank you so much, Ruth, for pointing that out. Let's see here. Is there anything in the legislative, Michelle, do we need to cut this short?
We don't. We can go for a little bit longer. I think I just wanted to pop in and because I know people are starting to leave because it has been an hour. To thank everybody for coming and to again give the course number, which is 9199. And we will get the materials to you. Yeah, I know we had a lot of questions, so
Yeah,
it's
yeah.
so if you want to go for a few more minutes, I believe that that's okay. Normally we're good until like 1:15 or so. So if you have the time and people want to
Yeah.
hang on, then that's fine.
I'm happy to keep spitballing. As you can tell, I'm just sort of making stuff up at this point because we're all treading into the what ifs and how is this going to be interpreted. I can only do so much, but I'm happy to try. Is there anything in the legislative history or elsewhere that discusses the definition of covered employee for remote or hybrid workers? I don't see that other than what we just read about principal place of business. What about the person that travels? The traveling salesman or someone who spends a certain amount of time in this state or that state. These are all going to be interesting issues as to whether or not they're covered or not for the purposes of the statute. Anne asked, such a poorly written statute, what county would apply? The one where it was signed or the one where the employee ended their employment? What if they moved out of state? Again, wonderful questions. And I think there's a lot of organizations right now that are reaching out to the governor's office to push back on signing this. Certainly could, I think, have used some input from a lot of people in this room with great questions as to why or how, and have you thought about this? So, you know, contact your governor. Palm Beach, average weekly salary, highest in the state. is 1,393 a week, which equals 7,243.6 a year. So they must make more than $144,000 a year. If less than that amount, can you have a non-compete, which is for someone making less, but enforceable only through the old statute? I think that's going to be part of that final provision we looked at, because it's so vaguely written, permitting other restrictive covenants being enforceable under the prior statute. Does that apply to all other non-competes, or does that apply to other forms of restrictive covenants other than non-competes? And I think that's going to be something that's going to have to be litigated. David asked, you've probably addressed it, but in reading the House bill, it does not look like it changes the current 542.335. That's right, Dave. That's what I was just talking about. So the old statute is completely intact, and the Choice Act references that and says that restrictive covenants that don't meet these definitions are going to be enforced under the old act. Again, I think there's going to be some fight over whether or not that means just non-competes too, or just other restrictive covenants. Are employer organizations reaching out to oppose? An unintended consequence would be an ability to find talent. Yes, I think Florida is really setting itself apart here. Most other states are, kind of pulling back from the non-competes they have in place. And in fact, some of the states we see that have the most trade secrets and the highest competition for competitive workforce, California, has no non-compete statute, and seems to be doing just fine. I think it would be, if there are employer organizations out there who might recognize the difficulty with bringing people in when they could be subject to a 4-year non-compete with no consideration of whether or not there's actually harm being done, is certainly a concern. So that is it for the Q&A. I'm not sure if there was anything else in the chat. I know people were putting stuff both places. Yep, I think that's about it. If anybody has anything, I'll go here, share my email address. It was on the first slide of the presentation. You're more than welcome to email me. It's easy. It's just james@delegal.net. And feel free to shoot me any questions you have. And thanks for listening to me ramble about something that is brand new, and hopefully it was helpful. So,
Thank you, James.
sure.
All right, and we will see you all at the next one we do.
Great job.